Okay, so we're going to start with a business law section, and then we'll go into the mortuary law, which will be after. This review is set up with the questions, and I've given you the answers. So that way, it's going to be easier for you when you study. You've got the answers here, and then you can just write down any additional information or annotations that you need for further understanding. If you have any questions, just ask them. Because as we go along, there are one or two questions in here that are purposefully incorrect. So you'll see where the problem is, so you'll be able to distinguish. So the doctrine of relying on a previous decision is called stare decisis. And that's utilized by certain judges when they make decisions and decide current cases. If they find similar cases on similar facts, basically what they do is they affirm or they reaffirm the decision, and that's stare decisis. The two types of powers found in the federal Constitution are express, which are specifically stated, and implied. An express power would be the federal government, for example, has the power over bankruptcy. They have the power over interstate commerce. And implied would be those powers that the courts basically have found were implicit in the original Constitution, because otherwise the Constitution of 1776 would not be relevant today. They couldn't use it because they certainly didn't have space travel, drug development, anything like that, airlines, radio, internet. The difference between a statute and an ordinance: they're both laws, they both have to be followed. Statutes are adopted on a federal and a state level, while the ordinances are on a local, a county, or a town level. What is the taking of property in the possession of another person against that person's will and under threat of bodily harm? Robbery. And that's different than burglary, which we'll get into in question number 7. What is the setting of fire to a building? Arson. The difference between a crime and a tort: a crime is an offense against society, such as murder, rape, pillage, and a tort is a personal wrong, such as conversion, nuisance, or defamation. Breaking and entering into another person's house in the night is burglary. I don't think you really have to worry about the night part of it. I think breaking and entering daytime, nighttime is not going to make a difference. American jurisprudence is based on English common law. And English common law is not codified. You're not going to find a book. You're not going to find something in the library that says this is English common law, because it's basically ways of living and mores that were brought over when the United States was settled. The stealing of a vehicle while in transit is hijacking. That means that the vehicle, a car, a train, a plane, has to be going from one place to another, but it doesn't actually have to be moving when the hijacking or the theft occurs, okay? It's not right here. The one state that was not founded or based on English common law is Louisiana, which is based on the Napoleonic Code or French canon law. The difference between bribery and extortion: both bribery and extortion involve two persons. The difference is, in bribery, both parties to the crime agree to do it. You ask somebody to do something, you pay them to do something that's illegal, they agree, that's bribery. In extortion, two people are asked, you force the second person into doing something. If you don't do this, I'll kidnap your child. If you don't do this, I'll burn your house down. What is the taking of property that is entrusted to an individual? Embezzlement. So the key to embezzlement is that the property that's being stolen or taken has to be entrusted to the person as part of their job. So the typical example would be a bank teller. The bank teller is entrusted with so much cash to work, and if the bank teller takes money out of the till, that would be embezzlement. What is the element of embezzlement that differentiates it from other types of larceny? Exactly, that the property has to be entrusted to the thief. What crime involves two people, in which they both have to agree, whether forced or coerced or voluntarily? Bribery and extortion. The two types of defamation: slander and libel. The difference between the defenses of defamation are truth, lack of publication, and privilege. Do you know what all three of them mean?
Yes, but if you were to ask me to say it right now, I wouldn't be able to do it.
Well, truth is truth. Truth is truth, meaning that what the person stated is true, so that's a defense. Lack of publication means that the wrong information was not spoken to a third
Is
party.
that like slang? Would that be
No. That it wasn't spoken to a third party. If you were my secretary and I called you in privately in my office and I told you that, I know that you were an embezzler and a thief and none of that was true, and then you got up and walked out and told your coworkers, there's no publication, because it has to be, dissemination of the information to third parties has to be made by the person making the slanderous comment. So the fact that it's just one-on-one, that's no publication. If I said it to 10 people or to 2 people other than you, there's publication. And then privilege means that it was said in a situation where there was a privilege, and the person who made the statement could make it and not worry about it. For example, if it was said on the floor of the legislature, or it was said in a courtroom setting, like where a defense lawyer would say to someone, you committed a murder, knowing that it's not true. That's a privilege, and that's an exemption. The more permanent type of defamation is libel. The less permanent type of defamation is slander. 3 examples of libel: recorded on a video, written, newspaper, recorded on a tape. What is the key element to have a cause of action for defamation? That the information was not true and published. So that means that if the information was not true, if it was a lie, that's a cause of action, and if it was disseminated to a third party. The difference between conversion and nuisance. You have to realize that the two, conversion and nuisance, are really identical torts except for the type of property that's involved. So the definition of conversion and nuisance basically would be denying an individual of the enjoyment of their blank property. That would be the definition. So with conversion, you would put in personal property, and with nuisance you would put in real property. So that's the difference between conversion and nuisance. It's the type of property involved. It's the exact same tort, but it's the property. What is the defense that one can raise in which it is alleged that both parties share responsibility? Contributory negligence. Do you understand how that works? How contributory negligence works? How the defense would work? When and how it's raised? You have a car accident. You're involved in a car accident, and someone sues you for hitting them. So in the process of the litigation, you have we're going to get into it later, you have the complaint and the answer, and you're going back and forth in discovery. And you, as the defendant, the person who's being sued for the car accident, your defense is, I accept some responsibility for this collision, but I'm not taking 100% of it. The other party shares responsibility. So that's contributory negligence. What is the name of the doctrine that judges use to compute damages? Comparative negligence. So what you have to remember, in order to have the judge use comparative negligence in deciding damages, the defendant must previously have raised the defense of contributory negligence. Okay? An example of how a judge would compute damages using the doctrine of comparative negligence: the judge finds one party is 60% responsible while the other party is 40% responsible. Does care and non-showing of negligence affect the outcome when wild animals are involved? No. In wild animals, chemicals, explosives, anything like that, you have the doctrine of strict liability. And no matter how careful you are or how many precautions you take, the person is going to be absolutely liable. There's no defense. They can't say, I did this, I did that. There's no defense. The 3 branches of government are executive, judiciary, and legislative. And are they equal? Yes. The 6 elements of a contract. These are the 6 elements that make up a valid contract. Offer and acceptance being 1, mutual agreement, consideration, competent parties, legality of purpose, and proper form. Now, later on we're going to talk about something, but proper form, there was something that we went over a whole, we had a whole lecture at one point on proper form. So do you remember the rule that dictates, that applies to proper form? The statute of frauds, which we're gonna go over later on, but the statute of frauds sets forth 6 types of contracts that in order for them to be valid, they have to be written. So written obviously is proper form because one of the forms is, oral, correct? So we'll talk about the statute of frauds in a little bit. What is a contract called when it's missing one of the 6 elements? If one of the 6 elements is missing, the contract is void, meaning it never was, it never existed.
Void is the same as voidable?
No,
No.
no, we're gonna talk about the distinction.
Right.
Void is where they're missing an element and there never ever was a contract. Voidable, we can talk about it now since you raised it. Voidable contract is a contract that has all 6 elements. It's absolute, you look at that contract, it's valid. But one of the parties to the contract sues and basically alleges that one of the 6 elements is not really there. For example, we have the requirement of competent parties. So if you and I enter into a contract and then you turn around and come back in the middle of the contract and you say, I'm a minor. So if it's proven that you're a minor, that affects the element of competent parties. And now if you're a minor, you're not a competent party, so now one of the elements is dropped out and now it's voidable because it's been proven. If you come back and we had a contract and you come back and you say, I only entered into this contract because I was threatened, so that takes away the element of mutual agreement. So then it's voidable. But a voidable contract is a contract that has all 6 elements, but you basically challenge one of them, and then that challenge is successful, you don't have the element, it's now voidable.
Okay.
Okay? What is a contract called when it's missing? Oh, okay, it's void. How is an oral contract created? By words. The difference between an express and implied contract. An express contract is a contract where all the terms are set forth specifically. An implied contract is where the terms are not expressed but are set forth by business operation or procedures. So a lot of times that the implied contract comes into effect with business practices. For example, I know specifically like with granite. If you go in and you order, you say 1 by 1, and you mean a 1 foot by 1 foot tile, because you're the customer, right? But that's not what it means to the people in the business. Apparently 1 by 1s mean the 1 inch by 1 inch put together. So it's implied there's certain things within a certain business where the people know the terminology, and you order 1 by 1, they know what they're going to supply you with. Now, also you should know that you have 2 types of contracts. This isn't written. There are 2 types of contracts you have, oral and written contracts, correct? So you have oral and written, and under oral and under written, you can have express and implied. So you can have an express written contract, you can have an express oral contract. You can have an implied oral contract as well as an implied written contract. All right, the definitions of entire and indivisible, which are synonymous, divisible and executory, and executed. So an entire or indivisible contract is a contract that cannot be divided into independent parts. Everything has to be completed at one time. If you buy a car, you don't buy the motor, you don't buy the door, you don't buy the tires, you buy the car. Okay. A divisible contract is a contract that can be divided into separate independent parts. So if you have a contract with a cleaning company to come and clean your house every week, basically what you have are 52 individual contracts, little 52 mini contracts. So the contract to clean your house for 12 months can basically be broken up into 52 minis. An executory contract is a contract that's in the process of being performed. So if you have a contract that goes from January 1st to December 31st, in June, that contract is executory. Okay? An executed contract is a contract that's fully performed. So the contract's done, it's over, it's finished. We spoke about void and voidable already. Do you have any questions on void and voidable?
No, I understand it now.
Okay, all right. In order for an advertisement to be valid, the offer must be definite. So most advertisements are not offers, okay? They're not, because they're very, come and buy it, we have it for sale. But it's very, very specific. That's where it becomes an offer. How must the acceptance be communicated? All right. Usually the manner in which the offer was made. So if it was spoken, it would be spoken. If it was written, it would be written. That's the general rule. However, the offeror, who is the person making the offer, correct? Right? The offeror is the person making the offer. The offeror has the ability and the authority to dictate any method that he or she wants the acceptance to be made. So what does that mean? That means that the offeror can turn around and say, here's the offer to sell my car. I will accept the first acceptance that I get that comes, United Parcel, UPS, next day, I will accept. So within the next couple of days, he gets five. He gets one by US mail, normal delivery, one by US Express mail, one by FedEx, one by DHL, and he gets one overnight UPS. That's the one. That's the valid acceptance. Because the offeror has the right to dictate. Okay, that's the rule. Absent a specific way, the acceptance is made in the way the offer was set forth. Okay? What is termination by lapse of time? Basically, you make an offer to sell something, it doesn't sit out there forever and ever and ever. After a reasonable amount of time, the offer stops. And if you go back and you remember in negligence, the basis of which, or the standard that the judges use is the reasonable man standard. The judges have this fictitious person called a reasonable person, and that's how they look at everything. Would a reasonable person have done this? Well, again here, the reasonable, which I can't say to you it's a week or 2 weeks or 5 days or 10 minutes. So after a reasonable amount of time, it expires. It also will expire by acceptance, acceptance, rejection, or withdrawal by the offeror. Two types of misrepresentation are innocent and intentional. Another word for intentional misrepresentation is fraud. The reason you need the distinction between them is so that you know what types of damages to pay. What type of damages does one receive for a fraudulent misrepresentation and for an innocent? For fraudulent misrepresentation, they will get compensatory damages and punitive damages. Compensatory damages are those damages that make the person whole, which brings them back to where they were. And punitive damages are damages to punish the person for basically committing the fraud. In an innocent misrepresentation, the damages would just be compensatory, which are damages just to make the person whole. Do you need an example, or do you understand that?
No, I understand.
Do you understand it? So you don't need an example of how it's, okay. What type of relationship is needed to have a cause of action for undue influence? There has to be a special confidential relationship, a teacher-student, and parent-child, some type of a mentor, that kind of a superior-inferior relationship to have undue influence. What allegations or cause of action is raised when it is alleged that bodily harm is threatened or threat of services? Duress. Those take it or leave it contracts are called contracts of adhesion. You see them all the time. You go to the dry cleaner and they have all these things you're not responsible for. You park your car in a garage, so you're not responsible. You leave your coat at a coat room, they're not responsible. So these are basically, if you're going to leave it here or do it with us, we're not going to be responsible. Those are contracts of adhesion. Then you have also, which isn't right here now, are the unconscionable contracts. And those are the ones that are so unconscionable, so unfair that the courts would throw them out. A lot of times you would see that I think the clearest example would be the people who maybe aren't that sophisticated and they've gone into these stores in the city and they bought appliances. But they don't realize, and they think that they're going to pay $25 a month 5 years and think they have this great deal. But when they figure it out and find out how much it's really costing them, they could have bought like 3 washing machines. So these are really unconscionable and shocking, shocking to one's conscience, where the courts will throw them out. The difference between a contract that is impossible to perform and one that is very, very difficult. We're talking about under pure contract law, not sometimes in reality where contracts are renegotiated, but under the pure contract law, if it's impossible to perform, of course, the contract's going to be thrown out because it may be illegal, maybe the zoning changed and they can't do it, so you can't do it. But if you miscalculated, you didn't realize something when you gave the price to do the contract, and now you find out it's going to cost you 3 times more money to do it, you still have to perform the contract. The reality is, you probably will renegotiate, but we're not talking about that here. What type of promise doesn't require an additional sacrifice? Now we're talking about consideration, and this would be a barren promise. Do you understand what a barren promise is?
You don't have to actually do anything to fulfill the contract.
No. Barren promise means that you have a pre-existing obligation. For example, the speed limit is 50 miles an hour. So your father, your mother said to you, okay, if you don't go over 50 miles an hour for the next year, I'll give you $5,000.
Right.
So you go for the next year and you don't go over 50 miles an hour and you go to get the money. That's a barren promise, because you can't be paid. You can't enter into a contract for something you're already obligated to do. You're already obligated not to speed.
That's what I mean, you don't have to alter your behavior at all.
Right, but if the speed limit is 50 miles an hour, and they say to you, I'll pay you $5,000 if you don't go over 45 miles an hour, that's valid consideration, because now you've given up the right to go 50 miles an hour. What type of promise is made where the promise does not require some additional benefit? That's a gratuitous promise. For example, a gratuitous promise is where you say you're going to do something, but there's no benefit going to the other person. So the example we use, which is also in the textbook, is someone said, an uncle says to his niece, or father to the child, says, if I hit a hole in one, I'll give you my lucky club. But there's no consideration, there's nothing coming back, there's no benefit coming back to the golfer. So that's a gratuitous promise, so that's not valid consideration. Contracts that are entered into by a minor are voidable. And on what side are they voidable? They're only voidable by the minor. If an adult enters into it with a minor, only the minor can walk away from it. The adult can't come and say, you're a minor, I want to walk away. Is a minor protected from his or her crimes? No. They're not. They're responsible. And you see all the time where a minor commits a horrific crime, a robbery or a murder or something, and you'll see in the newspaper, oh, well, they're going to try the person as an adult. Those are situations where the minor can't walk away from the effects of their their life, their torts and crimes.
Does it have to be that they're close to adulthood or no?
No, they have 12 and 13-year-olds who have committed murder that they hold. They can't just say, I'm a minor and walk away, so. Okay, again, here, what type of contract can a minor not avoid? They can't avoid their torts. Usurious agreements are illegal, true. And usury laws concerning usury are laws concerning limits on interest. So every state has a usury law, which is basically the maximum interest rate that you can charge. And anything above that is illegal. Since the law considers an intoxicated person mentally incompetent, what has to be done to have the contract canceled? The intoxicated person has to challenge the contract and state or allege that he or she lacked the contractual capacity at the time of the contract. The time you sign the contract. Usually what this becomes, it's not that easy. It basically becomes a court action or in front of a judge, where the judge evaluates and makes a decision saying, yes, I find at the time the person was intoxicated. But they have to make the allegation, they have to go forward, and they prove it. Then the contract is voidable because now you don't have a competent party. An agreement with a person who does not have the required license is not enforceable. So if you're a plumber and you're licensed in New York and you require a license in New Jersey, and you legally can't do plumbing work or certified plumbing work in New Jersey because you don't have the required license. What is champerty? Champerty is the encouragement of frivolous lawsuits. Basically, the stupid little lawsuits that clog up the court system. The act that forbids certain agreements that tend to unreasonably lessen competition. You have Sherman Antitrust, and then you have Robinson-Patman, which amended it and just made the scope broader. And basically, the two of them, you can't fix prices, you can't allocate territories, you can't limit protection, you can't make any agreements to lessen competition. You don't need to know the difference between the two, you just need to know they're both still in effect, and the Sherman Antitrust was broadened by Robinson-Patman. What is specialized knowledge associated with a particular business? Trade secret. What is any word, name, symbol, or device, or combination thereof adopted and used by a manufacturer or merchant to identify its goods? Trademark. Trademarks are slogans or signs or anything that the minute you see it, you know. You see the circles, it's Audi, or you see the Mercedes symbol, that, or the Cadillac symbol, or any kind of a jingle that is identifiable. Immediately, the minute you hear it, you know the product. So that's a trademark. What's the difference between a trademark and a patent? Okay. Patents are government-granted monopolies that are granted to the inventors of goods. Gives the inventor the right to make all of them basically gives them the right to make all the money off of the invention for a specific amount of time without any competition. Trademarks are symbols or phrases that identify the goods where you immediately know it. And then the third in this trilogy are the copyrights. And a copyright is basically kind of like a patent in a way, because it's another government-granted monopoly, but this affects artistic works, books, computer programs, pictures, images. So you have the three. You have trademarks, you have patents now, and you have copyrights. Out of the three, only trademarks are renewable. Only. The other two are not. Once they expire, it's on the market. That's why you have several companies that don't patent their formulas. You're not going to find a patent for Coca-Cola or Pepsi-Cola. You're not going to find a patent for Kentucky Fried Chicken, for the spices. And nobody knows them all, because once the patent is up, anybody can make it. So that's why they keep all that. They don't patent it, because they have no way of, after the patent expires, to protect their formulas, so they just don't patent it. They have people that can make stuff that tastes like it, but they may not have specifically the ingredients. What is it called when the employer is responsible for the actions of his or her employees? Respondent superior. So remember, with respondent superior, the employee has to be working for the employer, and it has to be within the scope of their duties, right? What is it called when the negligent act of one person is imputed to another? Vicarious negligence or vicarious liability. So in this situation, it's very similar to respondent superior, but there's no employer-employee relationship. So if you let's say you own a car and you have your boyfriend or girlfriend, you loan the car to your boyfriend or girlfriend. Not an employee, just your boyfriend or girlfriend. And they go out and they have a car accident. You as the owner would be vicariously responsible even though you weren't driving the vehicle. Okay? So that's where you have the vicarious negligence or liability. That's the difference between respondent superior and vicarious negligence, is that you have, in respondent superior, you have the employer-employee relationship, which is the important element. Parole evidence. Parole here is spelled differently than the parole out of prison, just so you know. And parole, in the parole evidence rule, means speech. Okay, that's what it means. And basically the rule is very simple. The parole evidence rule prohibits someone from testifying and contradicting the specific words of the contract. So the example that I give in class is, you have a contract that states that on the first of the month you will you will deliver 1 dozen red roses on the first of every month, 1 dozen red roses. So, so it's going along, and the red roses are coming, and June comes, and all of a sudden you get white roses. So now you see the florist, and you say, I'm supposed to get red roses, and you said white roses. So now you have litigation. And it goes, and the florist attempts to testify that yes, the contract says red roses, but we meant red roses as long as we have them. Under the parole evidence rule, that testimony is prohibited, because the language of the contract is clear. Red roses, not any type of roses, okay? Not red roses if we have them. So parole evidence prohibits the testimony. If you take that same contract where it says on the first of the month you will deliver roses, not red, this says roses, and you were delivering red roses for a period of time, and then you delivered another color, then if in a litigation, you can have someone explain what roses meant, because it's ambiguous. So that's how parole evidence works. Who is in charge at sea? The boat captain. He's in charge. How far out, if you do a burial at sea, is 3 nautical miles.
A quick question, does that apply to scattering ashes at sea as well?
No, that's different.
Yeah.
This is a body. We're talking about a body. If there's a death at sea on the boat, who is in charge of the disposition if there's a dispute between the next of kin and the captain? Give the 6 types of contracts that are required to be in writing for the statute of frauds. Agreement by the executor or the administrator to pay the debts of the deceased person, agreements to answer for the debts of another, agreements that cannot be completed in less than a year, agreements made in contemplation of marriage, which are prenuptial, agreements to sell any interest in real property, and agreements to sell personal property valued at more than $500. So, at this point, what is the exception to, there's an exception to the statute of frauds, which we have later on, but I'll give it to you now, are contracts for time and material. If you have a contract with a contractor for time and material, those contracts are exempt. What type?
You said what?
Time and material contracts. But with a contractor, they're exempt from the statute of frauds.
Okay.
They don't have to be in writing. What type of beneficiary is foreseen? Third-party beneficiaries. What is the difference in legal rights between an incidental beneficiary and a third-party beneficiary? The third-party beneficiary has the right to enforce the contract if there's a problem, because the third-party beneficiary was the reason that the contract was entered into, like a life insurance policy, like the beneficiary of a life insurance policy is a third-party beneficiary. An incidental beneficiary has no such rights, because an incidental beneficiary is somebody who would have benefited if something had happened, but they weren't the reason they were going to do the contract. The difference between an assignment and an novation. Both an assignment and an novation start off as